Hi everyone. Today in this video we're going to discuss about modern sources of Hindu law. In our previous video we have discussed ancient sources of Hindu law like what is Smriti, what is Shruti, what is commentaries and digest and what is usages and customs. But in this video we're going to talk about the modern sources of Hindu law. Modern sources of Hindu law. The various modern sources of Hindu law are: first one, justice, equality, and good conscience; second one, precedent; third one, judicial decisions; fourth one, legislature. We will talk about these 4 points one by one. First one, justice, equality, and good conscience. We all know that when the law is silent, we have to apply justice, natural justice, equality, and good conscience. It is also mentioned in the Smritis that if a decision has been made, then it has to be based on Yukti and Nyaya. Basically, Yukti means reason and Nyaya means justice. They say that a judgment has to contain Yukti and Nyaya, reason and justice. This justice, equality, and good conscience is applied by the Privy Council when a law is silent on a given point. And this trend of applying the principle of justice, equality, and good conscience was seen by the British in their administration. In the case Gurunath versus Kamal Bai, the Supreme Court of India recognized that in the absence of any rule of Hindu law, basically they said that if the absence of the rule of Hindu law, then the court have the authority to decide the case based on principle of justice, equality, and good conscience. This was held by Supreme Court in the case Gurunath versus Kamalbai. Moving on to the second point, precedent as a source of Hindu law. Binding nature of previous judicial decisions on a subsequent similar case is of modern origin and came into vogue during British period. The Privy Council expounded and evolved the principles and rules of various complex and complicated subjects of Hindu law through their decisions. This facilitated good understanding and ascertainment of principles of Hindu law without referring to the complicated spiritual sources, and also gave scope for adopting new suitable principles of Hindu law from relevant British concepts and doctrines. The principle of stay decisis is applied in the Indian courts. Basically, stay decisis is a doctrine under which it is necessary for the court to follow earlier judicial decisions when some points arise again in litigation. The judicial decisions of the Supreme Court are binding upon the all subordinate courts, but not on itself, and of the high courts on all the subordinate courts. Then comes judicial decisions. We all know that the judicial decisions can be followed the very next day, and a large number of judicial decisions now piled upon almost every point of law, which have superseded the law laid down in commentaries on several fonts. In the case of Saraswati versus Jagadambal, the Supreme Court has observed that judicial decisions on Hindu law are sometimes spoken of as a source of Hindu law. The Supreme Court said that the judicial decisions which was given from the High Court or Supreme Court can sometimes be considered and spoken of as a source of Hindu law. Last but not least, legislation. We all know that the law-making authority lies with the Parliament, and Parliament has the power to make laws on various subject matters. And legislation is a vital source of modern Hindu law and has to be important factor in the development of Hindu law. Like most of them are in the direction of reforming Hindu law and some of them superseded Hindu law. These legislations have not only brought in profound changes in the ancient Hindu law but also have made the law certain and defined. For example, Transfer of Property Act in 1882, which has superseded the Hindu law relating to the transfer of property.